Okay.
Okay, over to me. Good morning, everyone. So my name is Steve Devlin, and I'm an SEN project manager. So I am contracted to Hampshire County Council, but I don't work in the SEN service proper. I'm not operational. I work on very specific projects in the area of SEN. And why I've come today is when I was last at a HPCN event, I wasn't doing the role I am now. I was an interim assistant service manager, and I managed the complaints process. Essentially, there's different stages of the complaints process, but I managed stage 2 primarily, and some other parts of the complaints process. So while I'm not operational, I can't answer any specifics today. Even if I could, I couldn't, because I'm not in the service to be able to. I won't know any young people or their cases. Jane Howarth, who is the County Education and Inclusion Manager, would ordinarily do a session like this with something like explaining the complaints process. Jane's on leave at the moment, and we wanted to get a session in around on complaints because we know that was something you guys had been asking for. So I said, well, I'm happy to come along and do it. I used to manage the complaints process, and I can explain how the process all works from a kind of a process perspective, and a bit of an insight as to how the process works and how we go around investigating complaints, and explain what the routes are in and what the process looks like, how that works at a service level and how that works at an organisation level. I do have just some very brief slides to show everybody. It's not an in-depth presentation. Let's try and bring these up.
I should just be able to do it straight from yours.
I'm going to try and do this in presenter mode, which tends to always go spectacularly well. But I think we're there.
That looks good.
Okay, so it's just a couple of slides really to explain. So HCC, like all local authorities, have to have formal complaints processes. That it works slightly different across the whole organisation. You can imagine as a county council, there's lots of different services that are provided, and different teams have different ways of investigating, responding to complaints. When it comes to children's services, there are statutory requirements. There are things that the local authority have to do when it comes to complaints, and publish a complaints process is one of those things, and explain how the process works, how long time takes. So this is the formal process for complaint. If a parent wants to complain specifically about education, it all comes under Children's Services Complaints, who manage the process. So I'm just going to give you a very quick overview. Essentially, the link at the top of the slide here is the main landing page for complaints. So this sets out how you find the right team or service to make a complaint about, or a comment or a suggestion, or some good feedback, which we get from time to time as well. But this page will take you through to children's services. So if it's a specific education or special educational needs complaint, you would click on the main page, then click on the children's services page and follow the instructions for there. All the information you need to know about complaints are going to be on either the main landing page or the children's services complaint. And that will set out what the procedure are, what the timescales are, what you can expect, what the county council can investigate, and what they don't investigate about. And I'll cover a little bit of that around some jurisdiction stuff later on. But the main landing page and the information you need is going to be on that page, or the children's services complaint. So when it comes to a complaint specifically about special educational needs, there's 3 stages essentially. So the first stage is it's still formal in the sense it will be investigated and responded to, but it doesn't fall under the statutory timeline. It's a team level investigation. So there's always an encouragement when it comes to complaints to try and take that up with a particular team or individual first. And that's what we mean by a stage 1 complaint. So it might be typically an email in to one of the inboxes across the service, and a locality manager will take a look at that, and they'll try to investigate and come back with a quick response. So that's what we call our stage 1. and that's a team level investigation and response. If that hasn't been able to resolve the complaint or the issue at hand, then a formal investigation at stage 2 of the council's published response would be the next stage. So this is the part that I used to manage essentially, and how we work it, and what the investigation looks like and what you can expect. So this is a service level complaint and investigation. So this would be assigned to someone senior across the service to formally investigate along the timelines, and I'll describe what the process looks like for that in the next slide. But the format for that is very much that it's an investigation, there's specific issues are investigated, and there is a finding set out for each element of the complaint, and that will be in an upheld or not upheld format. So if the manager who's managing the investigation has looked at the evidence and spoken to who they need to speak to and come to the conclusion, yes, the service was at fault there, then it would be an upheld or a not upheld format. Sometimes with complaints, they cover a few areas. It's not just specific to special educational needs. It might be partners in children's services or somewhere across education, or quite a lot of the time, it's bits that don't fall under the jurisdiction of the authority at all. It might be something that's at a school level. Schools are broadly speaking autonomous of the local authority. There are things that we can do as a service when we are made aware of a complaint and we feel that there's a role for the local authority to deal with. But generally speaking, if a complaint is something to do with the school at school level, it's ordinarily unlikely that the local authority would be able to investigate that. That would apply to all local authorities. And that's because a school or whoever a young person is being educated are generally going to be required to have their own complaints process, and they'll be required to do their own investigation and respond to that first. So it can be frustrating, which we recognise, when the journey of education, particularly in SEN, has happened over many years, and things haven't gone right over a period of time. Sometimes it comes to the local authority and we're simply not able to investigate that. It's not under our jurisdiction. It's not something that we had any involvement in. It was all at school level, and there's a real set of limitations to what we can do. But either way, that's what we would call a service level investigation and formal response. So let's say that we investigated at stage 2, and I'll talk about the approach certainly that I took when I managed the process, when we've retrained across the service and we've looked at how we deal with complaints. I'll explain about the process, how we look to identify if we've been at fault, what we can do about that to remedy that, what we can try to do to get things back on track if we've drifted from a process, what steps we can take, and hopefully set out very clearly what we've identified and what we're going to do to try and remedy the situation. But let's say we've done that and we feel that we've done a thorough investigation, we've come to a conclusion, and you weren't satisfied with the finding at the stage 2 conclusion, you can ask for an escalation to stage 3, which is a corporate level review. Now, there's a really clear distinction here, and it's really important to be aware of this so it doesn't lead to any further frustration. But this is a review of the stage 2 investigation. It's not a review of the decision or the finding that was made at stage 2. It looks at the way in which the investigating manager undertook that investigation and the conclusions that they came to. You know, was it fair? Was it done properly? Was it done according to legislation? Was it done according to a particular local policy that we have? And again, that's not at SEN level, so that's gone beyond the service now. This would be done by a member of the information governance team, so within the corporate area of the local authority, not at the service level, and they would be looking at the way we conducted our investigation and the rationality of the decision that we made. And they would also take an upheld or a not upheld finding of that as well. So quite typically, let's say, for example, this was 6 months ago, and it was a complaint that I had investigated as the investigating manager. Let's say, for example, I came to a conclusion that it wasn't upheld, then there would be some questioning around, well, how did I find that to be the right finding? Was that made against the legislation? And I generally would be asked to talk through how I conducted that investigation and how I applied the legislation or the policy at the time. What that wouldn't do necessarily is if we were to do an investigation and we upheld or we didn't uphold, but either way you weren't happy with the decision that we'd come to and the finding, it doesn't necessarily say because you were not satisfied, you were unhappy, we're now going to change that decision. If I've had carried out the investigation, had it been a sound finding based on legislation, and I had found that, no, you weren't happy with the decision that was made, but the decision was made legitimately, it was made on time, and it was made in accordance with the legislation, then I haven't found fault because the service has not acted with fault. It's unlikely then to change what has been a not upheld to an upheld. So that's the 3 stages essentially of the process when it comes to formal complaints. Just going into a bit more detail about stage 2, and this is my last slide because I won't go into stage 3. And the reason I won't go into stage 3 in any more detail than I've done is simply because it's not something that as a service we manage, and I don't want to talk on behalf of information governance. They're responsible for their own investigations and way of working, and it wouldn't be appropriate for me to come on their behalf and talk. But I've taken this these first couple of sentences from that first website that I gave you the link for, and setting out generally what will happen at stage 2 when it comes to a formal complaint. So the first part is that you'll see it says processed by Children's Services Complaints Team. So Children's Services Complaint Team will acknowledge your complaint within 5 working days of receiving it, and they'll tell you how long they expect for a full reply to that. I just need to move everybody's face off because I couldn't quite see what I'd written there, but they'll tell you how long it will take to give a full reply, and the aim is to get a full thorough response back within 20 working days. But there's a caveat of that. Sometimes if it's a particularly complex complaint, it involves more than one service, over a long period of time, or it may involve external partners and we'd be limited on what we can say, or if there are key members of staff, key decision makers that we need to speak to, we may have to write and say we're not able to meet that timescale. This is a particularly complex complaint, or a key member of staff is going to be on leave for the next 10 days, then we'll write to you and explain why it's going to be longer, and we'll try to set out a new timescale for you. And we do that when it comes to complaints. If we know that there's going to be a delay, we will send a holding response to say there's going to be a delay and this is why. This is when we expect to have a response due. So in terms of the process really, so we would be notified as a service from the Children's Services Complaint Team. They would set out a synopsis of the complaint as it comes in, and they would assign it to us as a service. Historically, when I managed it, then I would look at who would be an appropriate manager and who would be appropriate to investigate and for me to have discussions with as part of that. But one of the key things we do, and we're pretty robust on this, is when it comes to assigning the investigating manager who will take overall responsibility for that complaint, we're pretty robust that it's not a manager who's had decision making on an operational level. And that's quite clear. That's in our policy. If a complaint was to go on to someone like the LGSCO, to the local government social care ombudsman, then we would be criticised essentially if we allowed ourselves to investigate ourselves. You know, if Steve made a decision and Steve investigated his own decision and gave a finding, we would be very open to criticism for doing that. So we make sure that along the process, the overall manager who's investigating that hasn't been involved in decision making. With an SEN service, particularly in Hampshire, it's a very big service. It's a growing service. The number of caseworkers, special needs officers and assistant team managers, certainly in the 18 months I've been around, has grown quite a bit as we expand to meet the current demand and capacity. And that allows us actually to be a little bit more flexible. And it gives us an opportunity to assign to managers or special needs officers in completely different parts of the county to investigate, so we can make sure that we're pretty robust around that. Now, the manager who will take overall responsibility for investigating the complaint, they will conduct their own investigation and they will set it out how they want to do it. They'll do it in line with the published policy. There is a published policy on the first link that I gave you that sets out how investigations and complaints should be handled. And there's some leeway there and some flexibility, but essentially they'll generally have their own approach to doing it. I know when I investigated complaints, I specifically liked chronology. I like to see timescales and timelines. I like to see what happened when it happened. I like to see evidence of decision making. And I specifically liked to have conversations with the people that were involved in that decision making, if they're still there. We do have movement, as any organisation does. And then essentially to draw my own conclusions and my own findings from what I've seen in terms of timelines and evidence and key decisions and records of decisions. And I was really clear in how I made findings when it came to complaints. And I know that the service has had a lot of training. I've delivered a lot of training myself on how we deal with complaints and how we find things. And I was really clear about, are we at fault? Firstly, can we investigate this? Is this within our jurisdiction? Is there an alternative route? Let's say, for example, if it's about a decision that has a route through to the tribunal, then we generally won't investigate that. That's not, we can make a decision that somebody is not happy with, but if we make a lawfully sound decision, we're not going to investigate a complaint about something where there is an alternative body that will make a ruling on that. So a good example can be, we quite often see complaints about a school that's named, but we wouldn't investigate that unless there were additional issues that we had to investigate. If there was complaints around communication about that, I might look at that. If there were issues around the timing about that, did we do it on time, in time, I'll investigate that. But if it's about the decision, it's a decision that could be made that you can mediate or go to the tribunal, generally speaking, we wouldn't investigate that. That would be outside of the complaints process. But this is in the policy, so it sets out generally what we do and don't complain. But then we'll look at our investigation, and I'll be looking at how we came to that decision. Was that a lawfully sound decision? Were we at fault? Did we meet up to the expectations we told you we were going to? Did we say that we would come back to you in 5 days, but we took 30 days and we gave you no reason why? Did we come back to you on the morning of day 6? But it was a particularly busy time of the year. So we'll look at that. We'll look at the way, or at least I would look at the way we performed against our service commitments, our process. But mainly I'm looking at the legislation and the process. Did we follow the legislation? Did we follow the process? If I find fault, I'll be very clear that I found fault, and I'll write that I found fault and it's been upheld, and I'll explain why. The service have had lots of training on explaining. We've reviewed against and we found that we should have done, but we actually did. So we found that there's fault and we've apologised for that. We may suggest a remedy for that. We may suggest some service changes for that if it's something that we've picked up. And I always like to say, and I've worked with lots of local authorities, complaints is a window into the service. It tells you what you do well and things that you need to try and tweak, taking aside any demand and pressures that's on all local authorities at this point in time, which is pretty substantial, we know. But if there's things that I would see that I think as a service we need to tweak, then I'll always give some feedback around that to other managers and ensure we do something about that. But the main thing that I'd like to impress upon the service while I've been around, and I know this is something that's carried over since I've stopped doing it, is very much about how do we fix that? How do we put something back on track if we have we haven't performed as we should, or we have made a decision we shouldn't have, or we were late, for example, then what do we do to get that back on? To the extent that the letters that we use are some very clear questions and prompts and guides for investigating managers. And right at the top of that is what legislation applies, what process applies, where is this young person in that process, what do we need to do, what's the next actions that we need to communicate, we need to do. So in a nutshell, that's how stage 2 of the process works. We know that complaints and comments and issues come to us through other methods as well. We know that some parents will write to MPs, and MPs will write into the service and ask that we provide a response. We know that some parents will like to write in to directors, and this happens in all local authorities. However, it will always come back to the service. So whatever route it comes in through the door, there isn't a fast track. And this is something that's really important that we share. It's the same service that will be looking, it's the same investigating managers. And if we pass that information back up the chain to the director or assistant director, who do always read what we write, absolutely, and they do always have their own decision, and they will always make their own changes to that letter. They are responsible for their own letters. They take a very interested view in what we do and how we perform. But at that investigatory level, it's always going to come back to the service. So it's important that I do share that there isn't a fast track that we can do. When it comes to any complaint or issue, it will all still come back to the service. And the first line will always be an investigating manager. We'll look at setting out that. Okay, I hope that was useful in explaining a bit of an overview as how complaints work. Happy to take any questions.
I've got, yeah, my chat is filling up, Steve. Do you want to just knock your slide off, and then we get a slightly bigger screen and super. Right, where shall we start? Several questions about remedies. People talking about they've had complaints which have been upheld, but actually there's never been a remedy. Or the complaint itself has come through, and then what the outcome didn't happen. So one of the questions is, have you got any published guidance on remedies?
We don't publish guidance on remedies, but we do pay very close attention to what the Ombudsman says when it comes to remedies. There has been a shift in focus recently, looking at remedies and looking at what we do with remedies and how we might try to minimize the impact going further. There has been some offers around compensation isn't really the word. If we can identify a way that something could be used to putting the situation back. A good example could be, I saw a complaint some time ago where we'd recognised that we hadn't arranged some provision in time for a young person that had moved in. So we took the view that, well, we could arrange for some over provision. We could finance that, or we could give that to the parent to finance themselves. So there has been a bit of a shift in focus in that. But essentially it's about trying now to make sure that things are put back. There's a point there about when remedies are offered or actions are put into a response that aren't then actioned. I know it's something that Jane Howarth certainly feels very strongly about. I know that Brian and Steve further up the chain feel strongly about that. And if I was an operational manager, I would certainly feel very strong about that. If we put a remedy or an action into a letter and it doesn't happen, we should take a very dim view of that.
And what does a parent do, Steve? If a parent has raised a complaint, you know, and you have to be pushed quite a long way to get to the point of raising a complaint. If you have found through investigating that complaint that there have been errors made and this should be the remedy, and then that action doesn't happen, what does a parent do then?
There's a couple of options. I mean, complain again. There could be escalation. What I would hope would happen is it would go back into the service and the service would deal with that straight away. It's very, very complex, and I can't give anybody advice on complaints. I can only explain what we do with complaints. I can't advise you how to write complaints better or what the process would be. And it's very, very complex what goes on behind the scenes because of the sheer amount of work any SEN service has to do. But essentially, someone will have responsibility for that. If there has been an agreed action that's put in, there will be an individual who is responsible for that. If it's operational, it will usually be a caseworker. But ultimately, they will have a locality manager as well who's responsible for ensuring that happens. The only thing I can say, we do need to know about that. If there has been an action that has been written into a letter and hasn't taken place, we do need to know about that, and that would need to be dealt with internally.
Okay.
The thing I can say is make sure we are made aware of that. But I do really, really want to stress that at a management level, we would take a very, very dim view and be very disappointed if actions that were going into letters are not being done. Those letters are coming from a manager.
I've got a little sort of synopsis of somebody's scenario. They say, I've raised many complaints with HCC. They keep repeating the same mistakes. They often don't offer a remedy. What are they going to offer to families who have repeated upheld complaints? How are they going to improve the service they receive so that they don't need to keep raising complaints? And you've just said that, you know, if you get a complaint and you get a solution, that your only way of ensuring that happens is to raise another complaint. And as a parent, that seems completely unsatisfactory.
I mean, I can't add any more.
Okay.
I've said. I mean, that shouldn't happen. There's absolutely nobody in HCC or any authority that I would expect to try and defend that. You know, if we are not doing the actions that we've said we'll do, you know, there is no defence for that. Those actions should happen. If it's something that should happen anyway, it should happen. If it's something that we have, as a manager, written is going to happen, I can't think of a single manager who would not be extremely frustrated to hear that their name was on a letter and then actions didn't happen. I know that does happen, you know, and I know that because I remember when I used to write the letters and they used to have my name on them, and I know how I used to feel when I would then find out that a letter with my name on it resulted in something not happening. But, you know, I've nothing more I can really add than that.
Let me see. Would you investigate the local authority not providing evidence and delaying a tribunal case from going forward, leading to the tribunal service having to issue an order to provide the evidence?
No, if it's within the realm of the tribunal, I wouldn't expect any local authority to do so. The tribunal managed the tribunal.
But what that complainant is saying is that the SEN's feeding into the tribunal service has basically failed. So they're not providing the evidence in a timely manner, which has resulted in the tribunal being delayed, which is obviously resulting in the young person or child in question having the decision which might support them being delayed.
I mean, I say this as somebody who's represented countless parents in the tribunal and local authorities in the tribunal. If the tribunal are unhappy with the way the local authority are conducting themselves or engaging or being uncooperative through the process of the tribunal, they will let the local authority know. And if they feel it appropriate to criticise or to bar the local authority, they will do that. But it's a matter of jurisdiction. The process of the tribunal is entirely managed by the tribunal. And it was not something I would expect any local authority.
So effectively, it's the tribunal that would make a complaint, is what you're saying. The tribunal service would make a complaint to the local authority.
If the local authority,
they weren't happy,
the tribunal had thought that the conduct of the local authority was questionable, that they had failed to do anything that the tribunal had ordered them to do. Let's say, for example, there was a clear order to have consulted with schools X, Y, and Z and provide a position statement by such and such. If the local authority, any local authority, failed to do that and the tribunal were unhappy with that, the tribunal would let the local authority know there would be criticism of the authority. And there might be, and this does happen up and down the country, a barring order. You know, generally speaking, the tribunal will give the local authority an opportunity to put something right. If they've missed a time scale or they haven't provided something the tribunal have asked them to provide, the tribunal will generally say, you know, you've got to fix this, you've got to put this right. But ultimately, it's entirely up to the judge that's managing procedures. And if they are disappointed in the local authority, they can issue a barring order.
Since you've mentioned judges, I'm just flicking back to find a question which I think follows on nicely from that. And I'm just trying to find it so I get my wording right. But the question is basically, where is it? Is there anything within the complaints process that can help you get things unstuck, like the telephone case management service within the tribunal service?
I don't fully understand.
Okay, so within the tribunal service, if things aren't moving along, you have the ability to do a telephone case management service, and you can book a call with a judge who's independent of your tribunal, and they can look at what's going on, and they can oil the process, if you like. You only get to do it once. You get to do it once in the process. So I think what the questioner is asking is there a way within the complaints process that you can, if it's all getting stuck, that you can find a way to unstick things?
Okay, I think I understand. No is the quick answer, and I can understand the argument for that when things aren't moving, you know, the way you want them to, or you know, there's delays. And I honestly, as someone who is an advocate for parents as well, I understand the frustrations of when this happens. But what I think that would mean in reality is simply another process. Everything in SEN is a process. This is something that whenever I do any training with the SEN service, they'll tell you what my three magic words are. And I always say any good SEN service knows the legislation, knows the process, and they know its system. So they know how they can do those things. They're the three basic things any local authority SEN service needs to know and understand. And I repeat that, you know, all the time. And one of the key messages I always say is you've got to be process driven in SEN. Young people are always in one form of process or another if they've got an EHCP. They're under an assessment, they're under an assessment. If they've had a plan written, they're waiting for a review. If it's a review, it's a review. If it's an amendment, a cease, so on. So you're always in one process or the other. There is no process in SEN that doesn't have timescales put to it. Whether a local authority is adhering to those timescales, well, taking aside the huge issues all local authorities have with meeting timescales because of the demand on them to do so, taking that aside, because that's not, you know, for parents, that's something local authorities have to get their head around. Taking that aside, I will always say, where is that young person in the process? But everything is process driven. I don't think I would ever encourage any local authority that I work with to add more processes, because all they're going to do is miss other ones. It's an incredibly bureaucratic set of systems when it comes to SEN. And I can see the logic. I can see what else can we do to...
you know, I hear what you're saying, Steve, but I am seeing increasingly parents getting so frustrated that they aren't, their young people aren't being put through the process in the timely fashion that the process lays out, that they're not hearing about settings, that they're not, and they can't get through to people to talk to, that the course of action they're ending up taking is a complaint. And that frustrates me endlessly, because I don't want our SEND department dealing with complaints. I want them dealing with provision for our children and young people. And, you know, we have a mediation service in the tribunal, so that's another process in the tribunal that tries to avoid us getting to the point of tribunal. And I just wonder whether we're getting so bogged down in complaints because we're not doing stuff well at the beginning, that those complaints are taking away from everything else that we do. So maybe one of those processes in the beginning would actually reduce the number of complaints.
No. What the answer is, no one, I don't think anyone can disagree, is local authorities should be doing the things they should be doing. Okay. Yep. There is no local authority I know that doesn't just want to do the things that it should be doing. The issues are very clear, that there's 13,000 EHCPs and there is a finite number of resource. Now, I'm not going to go into all of the work around bolstering the service and service improvements, because I'm not involved and it's not what I'm here to talk about. But there is a reality and a pragmatism around the reasons why, and this is all local authorities, whether you agree or disagree, and I work up and down the country, they all face exactly the same issues. And the issue is numbers, rising numbers of assessments, delays in assessments, availability of special school places. They're all the same issues up and down the country. And what that means is lots of authorities just simply aren't performing. You know, I know of assessments that have taken 2 years in other authorities, and this is absolutely unacceptable. No local authority can defend that, but it's about the capacity and the demand and the ability to do that. No local authority should be managing their processes via complaints, but I recognise lots of them do. I've had to do it myself. Even simple things as getting a review letter, I've had to write letters of complaint to get those out for parents. That's the reality of what's happening to local authorities. They are struggling to meet what is a massive demand.
But it becomes a self-fulfilling prophecy, doesn't it?
It does, absolutely.
You can't do the things well that you need to do well because you're so busy tidying up the mess from not doing things well.
I know. I absolutely agree, and I don't think anyone would disagree.
I mean, I've got parents saying, you know, we can't get through to, you know, our caseworker on the phone. We can't get them to reply to emails, and therefore we're writing complaints. And to me, that seems blatantly like there's a problem, because actually we don't want to be talking about complaints, do we? They should be the exception, not the norm.
Well, I'm not disagreeing. I'm absolutely not disagreeing. I've said that back many times. You are managing things via complaints. That's not what you want to do. But SEN services are aware of that. It's the same people that will be asked to provide chronologies and timelines that will be processing. It's the same amount of resource. You know, I'm not encouraging people not to complain. There are valid reasons for complaining, and I hear that. But it's all the same people dealing with all the same amount of work. And it's in no local authority's interest at all to manage things by complaints. You know, when Jane comes back, talk about service improvements, what they've done. I used the sentence earlier, your complaints are your window into your service.
Yeah, and do you know what, that's really interesting. I really like that. I used to be a Waitrose manager. And so my Waitrose is all about customer service. And we used to get told that a complaint gave you the opportunity to turn a situation around for a customer. And so that actually at the end of the complaint, they'd go away saying, do you know what? They mucked up, but actually I'm so impressed with the results. The problem is we're not achieving that at the moment. And what we're achieving is scenarios where the complaints potentially are coming through, but then the remedy isn't being upheld. And so people are having to complain again. And that's, you know, anyway, moving on.
All I can do is, you know, I can acknowledge that frustration. You know, I'm not going to disagree on that. I managed the stage 2s for long enough to see where things were getting better and where work still needed, and I managed. You know, I acknowledge all those frustrations. I'm not going to say that they don't exist.
Okay, I've got quite a specific question, which I think comes back to what you were talking about with remedies and what remedies could be offered. If local authority delays have caused a child to miss 5 years of education, can they then have 5 years of appropriate education when they do finally get through the system?
No, I mean, a young person, you can provide from where they're from. You can take meaningful actions to try and put back as best you can remedies. I mean, I without knowing the specifics of a case, and I'm not going to ask about the specifics of a case, you know, it's not necessary. I wouldn't necessarily think that all of those delays would be a local authority causing 5 years of risk, you know, education, because I understand that education is much broader than just the local authority. There's the responsibilities of schools, there are services within local authorities. There's lots of factors that would create a situation like that. what any local authority can do is they can extend things like, you know, the amount of time a young person can go to school for. That would be beyond their control. There'd be some flex if it was post 16, so there could be work around that. Certainly in remedies before that I've seen in terms of what goes into EHCPs, if a young person, I won't say which local authority I was working for at the time, but I was brought in to do a piece of work to find 17 young people because the local authority, and I won't say which one, had lost them. And when I found them, and it took me a long time to find them, which was worrying in itself, there were things that I was very, very shocked and unhappy to see, and said you need to take immediate action to fix X, Y, and Z. So there can be some flexibility around, well, okay, well, that young person is this age. What we can't do is extend their time in school beyond here. But what we can do is make up for it by doing X, Y, and Z in here. So there is a limit to the remedies and what can be offered. But, you know, I go back to that thing about local authorities paying close attention to what the Ombudsman says. What would the Ombudsman think to be an appropriate remedy for that? And I've certainly encouraged that shift in focus to get it back on track, try and remedy that, try and put things back to being right as soon as they can. Caveats and limitations. Right.
Mentioning LGO, let's go back. I've got one somewhere up here about that. What are Hampshire learning from LGO decisions? There seems to be a lot of reported breaches in legal duty.
That's an interesting question and a good question, because the answer is lots. Whether you see that on the front line, whether you experience that as parents, I can't go into, and I'm sure that question is born out of some frustration around something.
I'm sure all of these questions are born out of frustration, Steve.
Yeah. But what I can tell you is that a couple of weeks ago, I gave a 2-hour presentation to the entire service on the Ombudsman and looked at all of the service improvements and all of the things that were picked up. If anyone reads LGO Decisions, they'll know that there can often be some strategic work that the Ombudsman will expect from the authority. So they might say, we've taken a look at this and we've had a number of complaints about a particular process, so we're interested in the way you do this process. And Hampshire, like all authorities, haven't always got things right in their process. They've had to tweak their process. I've seen that, because that I have been involved in. But one of the things I talked about was that the Ombudsman wants evidence. You have to provide evidence. So they will expect to see things like, how did you communicate this? And if it was something like ensuring that staff know something has to happen, then there's the way we work through our whole service comm cell. There's the way that we pass information down through managers to individuals. There's particular process changes. So there'll be standard operating procedures for everything. All local authorities will have standard operating procedures. They are and they should be kept under review. Case law and changes in legislation will affect your processes. Over time, I've come across lots of local authorities whose standard operating procedures haven't been right. They've been based on what a person thinks the process is, not necessarily what the legislation says the process is. So if there's a change to a standard operating procedure, the Ombudsman wants to see it. So Hampshire, like all authorities, will have to provide evidence of that. So I was talking through a couple of slides specifically on these are the things that came back. I managed the LGSEO process for a while as on an interim basis back in, I think it was
LGSEO. I'm struggling with the acronym, Steve.
Local, the Ombudsman.
Okay. It's got an extra letter in it.
So it's the Ombudsman, essentially. Yeah. So I managed that process for a period of time. I know what's involved in that, and I know what the Ombudsman expects to see when you have to provide evidence of strategic changes and process changes.
Okay. Why won't Hampshire look into a lack of providing provision from an EHCP if a parent has complained about a historic lack of provision? The breach is an ongoing breach and needs to be resolved without delay.
Way too individual for me. So
I think what it's saying, if we break it down, I think what it's saying, because a lack of providing provision, I presume, is at school level. So can you complain to the SEN team about a school not delivering what's on an EHCP?
No, well, yes and no. Remember as well, and there are a lot of myths when it comes to who is responsible for what in SCN. We know things like Section 42. That's an undelegable duty. You know, the duty to secure is always going to be the local authorities. But there is an area of pragmatism about this. No local authority in the country can ensure that every single child, every single minute of every single day is getting the provision in their plan that is delivered by the school, who are responsible for delivering that provision on a day-to-day basis. We would all like to, because ultimately the complaint comes back. There's a question around provision not being put in. It will come back to the local authority and we will be required to investigate that. If it's about not securing provision, that's absolutely with the local authority. But these are the complexities and the realities of SEN. If it's something that's in an EHCP and that local authority has named that school and provided funding to that school and secured the provision in that school, if that school on a Tuesday decides not to do it, the complaint will come to us, we know that, but that's really down to the school on a day-to-day basis. It's not always helpful. I say this as a broad statement. There's a lot of very unhelpful information about who does what and who sits with responsibility. If it's something about securing, if it's something that is nailed down in law, a local authority is responsible for doing that. That local authority is failing to provide that complaint to the local authority is absolutely legitimate. If it's something that a local authority pragmatically and reasonably, and that's a really important word, cannot influence on a day-to-day basis, it might be the case that while we investigate that, we would refer you back to the school to say, why did Jimmy not get his LSA at 3 o'clock on Tuesday? You know, there is a level of reasonableness about that as well. There's something, the reasonability test, you guys might have heard about that. Could any local authority in that position do that? What else could they have done differently? And we do apply a little bit of that as well. Ultimately, if you have reason to complain and the complaint comes in, we have to look at that complaint as it comes in.
So ultimately, I think the answer to the question is, if provision which is in Section F and therefore legally enforceable isn't being provided, then yes, you can make a complaint, and then you will look at that.
It isn't. If you feel that provision isn't being secured by the local authority through Section 42, you're entitled to complain, and that authority is entitled to investigate and respond to that.
Okay. Super. I think it's one of those really tricky ones where people, where do you go to when you've got as far as you can with the school? Super. Right, I've got another one. Getting to the end, but I've got one other one here. Where's it gone? What would you recommend as the correct route to complain at first if a request was refused? I presume that means a request for a complaint was. Let me read it again. Let me read it as it's written.
Okay.
What would you recommend as the correct route to complain at first if a request is refused on the direct orders of the assistant director? I'm reading what's written, Steve.
Yeah, I can't make a recommendation around that. It's just too broad, I'm afraid. And I suspect that it will become more specific and individual as we try to unpick that.
Okay. Oh, one more here. You mentioned, I think, on about the second slide about some retraining. Was it for complaint handlers?
Yeah. So when
somebody has said, when did the retraining take place?
So there was 2 rounds of training. When I first came in September 2020, I was an interim. So for you guys that don't know, I do 2 things. I'm a SEN consultant. Process and legislation is my bag. I'm very geeky about it. I'm very strict about legislation and process. The other part of what I do is I've owned an advocacy and mediation company for a number of years. I'm a qualified mediator. And I represent a lot of parents in the tribunal and hopefully before the tribunal. So my skills really are around some of the independent investigations. I've done independent investigations for other local authorities. So some local authorities, they will all handle their complaints process differently. But in some cases, it's appropriate to have someone external come in and take a review of the way a complaint was done. So I've done that for lots of other local authorities. So when I came in and they said, would you look after stage 2 and LGSEO on an interim basis? I said yes. And I saw what was coming through in the way we were processing our complaints. I made some recommendations. So I did some broad service level training in, I think it was December 2020. But then I did some very specific higher level training back in April 2021. And a lot of the stuff that I'm saying today, there's a lot of the stuff in the training about how you approach a complaint, how you investigate a complaint, what's appropriate, what isn't appropriate. But a lot of that going back to being procedurally fair, making sure you've looked at legislation, making sure you've made rational findings around that. So the training isn't anything that you guys wouldn't expect in training. It's around how do we investigate, what does fault mean, what do we do about that, how do we try and fix that.
I think when people ask a question like that, it's because they've made a complaint and they feel it hasn't been handled appropriately, and so they want to see where their complaint was in the time frame versus the training. That's when I'm guessing, but I can see that's where a question like that comes from. It's
Yeah, fair enough. How I will answer though is all complaints and all letters that go out, and this isn't just Hampshire, but I will answer specifically to Hampshire. It doesn't just come from one person. So it will always go through some form of quality assurance. So from whoever first drafted that letter, whoever investigated, whoever checked that letter, whoever checked it for, whoever proofread it, it goes through stages at each time. That's all local authorities, but I know specifically, let's say, for example, there was an investigation and the Director of Children's Services wanted to respond to that. It would go through an assistant service manager, a service manager, a county manager, an assistant director and a director. At any of those stages, if it was felt what was written wasn't appropriate, needed tweaking, needed further addressed, something hadn't been investigated, at any of those stages, it could be sent back and it would go through again. So, I'll say this fairly, there is a difference between somebody being satisfied with what's been put in a letter and that meaning that letter hasn't been appropriate, because it has gone through several stages before it's been issued. That's the same with all local authorities, really.
I think it's back to your window though, isn't it, Steve? That letter is a window and that response is an opportunity. And sometimes we miss those opportunities with those response letters, potentially.
I know this isn't necessarily what everyone wants to hear, but we are entitled to disagree.
Yeah, and I think, I'm sitting here, and I have to put forward both sides, and I know that people, sometimes complaints are made out of disagreements, that people have a difference of opinion, and as opposed to a fact. Yeah, and I get that.
Yeah.
I get that.
Keep in mind,
What about? So I've got a question about, and I think this is a fair one. What about a scenario where a complaint has been made to Hampshire, which has then been elevated and gone to the local government ombudsman, and there it's upheld? Because that's surely saying we've got something wrong.
Yeah, well, if the ombudsman process is a process in itself, and it's quite an in-depth process. A lot goes on when it goes to ombudsmen, and there's an opportunity for local authorities when a draft response comes in, a draft decision, for local authorities to go back and say, well, actually, we disagree X, Y, and Z, and an opportunity for whoever's made the complaint to do the same. If it gets to the point where the ombudsman is saying, we've been through all of that process and we found fault here, here, and here, we have the opportunity to agree. And if we have agreed and we've taken the recommendations, it means we have realized that we're wrong. And we, like all local authorities, like all decisions, we give the decision based on the evidence that we have at the time and the finding at the time. And if that turns out to be a flawed decision later, that can happen. things can come out at different times that we perhaps weren't expecting or we didn't have, or the Ombudsman, the way they work is they have their own view of something. So they want a whole set of information that we simply hadn't considered before because it hadn't been specific to that complaint. But they will ask for that and we'll always comply with that. And if it's a flawed decision, we would accept it's a flawed decision. It's the same as the tribunal. Decisions are made based on the evidence and what the local authority believes is the right decision at the time. And a external party arbitrates and says, no, we disagree. We think that's the right decision. You know, no local authority gets the decisions right or wrong all the times, but what they can do is they make a decision based on what's available to them at the time. One other thing I just want to add quickly, Sarah, just to say, going back to the question before, we are really clear that if at stage 2 something hasn't been investigated or the parent comes back, we do frequently send a further response. We do go back and investigate again. I've done this many times myself, and often, for example, I've given a finding on something and a parent said, but I don't think you've considered X, Y, and Z. Now, I've quite often said, if that's a new complaint, that was not part of your initial complaint, I'm not going to give you a further response. You can make us further complaint, we'll investigate that. Because otherwise we will go continually. If I say, okay, fair enough, you're saying this, and you're right, I've reflected upon my initial finding, I didn't take that into account, or the information provided to me, you're telling me is incorrect. You're saying A, person that I investigated told me B, let's go and look further, and we do come back and give a further response to that as well. Or stage 3 would happen. If it's appropriate, I quite often would ask another, when I used to manage them, I would ask another manager to do that because I would say, that was a decision I made. It's not appropriate for me to reinvestigate, my own decision. So we do that, and there is a requirement that we would do that as well.
I'm conscious of time, Steve, and I think my frustration really with the system is for those young people who haven't got the incredibly proactive parents we've got on the call today, who aren't getting the provision without the complaint, and their parents aren't going to make the complaint. And I think, I guess our ambition has to be that we don't need complaints, doesn't it?
I'd sign off by saying something that I say at a lot of meetings. If I talk to parents, if I talk to local authorities, all local authorities have things they do well and things that they don't do so well. They all have challenges and they all face really unprecedented demands. The demand on all local authorities up and down the country, this is why there's a SEN review, isn't sustainable. The number of assessments, number of plans, number of places, all that perfect storm really places a lot of pressure on all local authorities. I absolutely understand the frustration and have written thousands of letters over the years on what should be very simple things. I shouldn't have to complain just to get this letter that you shouldn't have sent me. So I get that. But what I can say is individuals in SEN, they do just want to do a good job. They do just want to do the job that they're paid to do. They work within the resource available to them. And they're well aware that a complaint is more work on top of the work they've got to do. But I agree, and I stand by that comment about it being a window into the service. I stand by that, you should always have, all local authorities should understand those things, and they should have that, culture of continual development and improvement. No local authority wants to run its comms by complaints.
No, absolutely. Thanks for your time, Steve. Thanks to the parents that have joined us. There is, and I will try and find a link to share on our pages. There is another session I did on complaints with Sendius a little while ago, which takes you through the process as well, that might be of use to some people. We've covered a lot of ground. I appreciate we probably haven't answered every single question, but I appreciate your time, Steve. Thank you to the parents for joining us, and we hope we will see you again soon.
Thanks, everyone.